But I'm going to start off by talking about some basic legal concepts, and then we'll build into more complicated concepts. And then we'll end this presentation by talking about recent changes in the law, so that for those of you who have an existing estate plan, you'll be privy as to what the changes in the law are and what's coming. And for those of you who don't have an estate plan, we'll cover that initially just so that everybody's on the same page as to what these documents do and how they work. So thank you so much, Vania, for posting those handouts. So if you didn't get a handout, please feel free to grab it from the chat and print a copy. Pretty much everything I'm talking about is covered in the estate planning and probate handout if you'd rather just listen and not have to take notes. And then again, if anything is a personal question in nature, if you want to just email that to me separately so we don't take people's time with personal questions, I'm more than happy to answer general and open questions as we talk through about these different documents and how they work. So probably the most common question people will ask me is, who needs an estate plan and what type of an estate plan? Because that's always a good place to start. And the answer to that question is, in the state of California, once a person turns the age of 18, at a minimum, they should have two documents that are called a durable power of attorney. And the way a durable power of attorney works is you nominate an individual that can be a financial advocate and a healthcare advocate in the unfortunate circumstance that you lose capacity. When you're a minor, your legal guardian and parents automatically have the ability to make your financial and medical decisions. But when each of us reach the age of majority, which is age 18, your parents and legal guardians lose that right, as a lot of parents know when their kids go off to college. And legally, if your adult child or anybody, you know, for that matter, were to lose their capacity, whether it's temporary, like in a medical situation, or more permanent, like in a diminishing capacity situation, the benefit of having these documents is you avoid a court process called a conservatorship. So a conservatorship is a legal process where you petition the probate court to be given a person's ability to manage their finances when they lack capacity and can't do that for themselves. And or you can also petition the probate court to be appointed as a medical decision maker for a loved one who doesn't have the ability or capacity to make their medical decisions. But when you do an estate plan, you're typically going to be creating 4 legal documents. 3 of those documents are financial, which is the trust, the durable power of attorney for financial affairs, and the pour over will. And then you have a separate document that is medical that's called a living will. It's also called an advanced healthcare directive. It's also called the durable power of attorney for medical decision powers. So one kind of problem, if you want to call it problematic, with estate planning is it seems like there's 10 different words that all refer to the same thing. So I'm going to start off first by talking about a medical directive, and then we'll transition into talking about the 3 financial documents, which is the trust, durable power of attorney, and will. So when you create a healthcare directive, you're basically nominating people you know and trust that can make your medical decisions when your doctor doesn't believe that you have the ability and capacity to make those decisions for yourself. To me, a medical directive is one of the more loving documents in an estate plan, because most of us don't talk to our loved ones about our preferences and ideas about quality of life, organ donation, burial preference, life support. And those are the few decisions that I do ask my clients to make in those documents, which takes the burden of having to make those decisions off of your loved ones during an already difficult emotional time. So when you create a medical directive, there's actually language within it that says that a copy of that document will be treated like an original. So that is the only document in an estate plan that I encourage my clients to actually share a copy of that document with the people that they've named. And the benefit of doing that is, if I named my father, for example, to be my healthcare agent, and if my husband and I were both hit by a drunk driver, and if my husband and I were both on the hospital incapacitated, by having given my dad a copy of my medical directive, which says that a copy will be treated like an original, when he gets the call that there's an accident and that we're both in the hospital, my husband and I, then my dad can take his copy of my healthcare directive, give it to the hospital, and that will enable my dad to step in and to make my medical decisions when I don't have the ability to make them for myself. So when you create a medical directive, it is important to give a copy of it to the people that you've named. You also want to keep track of who you've given a copy of that document to, because you do want to update these documents about every 8 to 10 years because the legal language becomes stale, for lack of a better word. And in the 3 financial documents that are in an estate plan, the tax laws change quite often. And these documents are very tax specific and driven, which is part of why when you have an estate plan, a revocable estate plan, which means it's amendable and changeable, from a maintenance point of view, you do want to revisit these documents about every 8 to 10 years at the latest. Now, I know a lot of people at UCSD have the ARAG legal insurance, which is a fabulous benefit that's offered. I believe open enrollment is probably happening now or is around the corner. And estate planning is covered through your ARAG legal insurance. So sometimes people with ARAG will review their estate plan on an annual basis, if nothing else, because they want to know what changes have occurred in the law. Sometimes people want to make sure that their assets are titled properly. And then other times people just like a refresher to walk through these documents and to know what they say, which gives them the opportunity and ability to decide whether or not they want to make any changes to it. But you don't have to review these documents that often unless you want to. I just mentioned the ARAG legal insurance because estate planning is one of the covered benefits of that legal insurance. So if you have it and if you haven't used it, now would be a great time to use it because these hours do expire at the end of the year. They don't roll over. So if you don't use your insurance in 2024, you basically just leave all that coverage on the floor because 2025 is a new year with new benefits. But it is a great program. So when you have that healthcare directive, what the other thing that I encourage clients to do, which is on our documents, is the last 2 pages of our healthcare directive. We give our clients the ability to write down the names and phone numbers of the people that they've nominated to make their medical decisions, in addition to listing any medical information if they want to list that, and then putting their medical insurance information on that document as well. And part of why that information can be important is because I keep a copy of my healthcare directive and my spouse's in the glove compartment of all of our vehicles, because if we were to get into an accident while driving our car, having that medical directive along with medical insurance information and the phone numbers of the people that we've nominated attached to that document can be very beneficial, because oftentimes the firefighters, paramedics, police officers will go into your glove compartment looking for your license and registration. And if your medical directive is there, then it's that much more likely to be brought to the hospital with you. So I also encourage my clients, when it comes to the healthcare directive, to take a copy of that and stick a copy in their suitcase. Because as you can imagine, anytime you travel, the only thing that the people that are at the hotel would know about you if there was an accident is they only know your name and your credit card information. So if you have that healthcare directive in your hotel room in plain view so that somebody who comes into your hotel room would see it, that also would be very beneficial to travel with and to leave in an open space in your hotel room or your Airbnb or wherever you happen to be staying. So a medical directive, as I mentioned, to me is one of the more loving documents, because I do ask my clients if they're comfortable to make just certain decisions about their burial preference. You have the choice of being buried or cremated, and by being cremated, there's water cremation or fire cremation. You also could choose to be composted, which is going to become legal in 2027. And there's other options as well. So I'm going to take a drink of water. But those are the most common burial preferences that people tend to pick as far as being buried, cremated, or composted. I know that off of Florida, for people that like the ocean and are scuba divers, there's this thing, I believe it's called a natural reef, where they can mix your cremains with cement and turn your cremains, excuse me, into a reef out there. There's also the jewelry that they make with cremains. Sorry, I just have a tickle in my throat. So when it comes to your healthcare directive, you can be very specific about what your preferences are as to all of those things. And if you've already paid for your cremation or burial, That's also helpful information to include in the healthcare directive as well, so that your family doesn't duplicate those payments. And then in the medical directive, another thing I ask clients if they're comfortable making the decision so their loved ones don't have to make it, is I'll ask them what their preference is about organ donation, because many people are willing to donate organs and tissues to save a life for transplant purposes. Other clients are willing to donate their skin to burn victims. Other clients are willing to donate their body to medical research, science, including being a cadaver. But there's so many different things now with modern technology that they can use our skin, cells, tissues, and all of those important things for, that it's important for you, if you're comfortable, to let your loved ones know what your preferences are as far as organ donation, because that has become a very broad and expanded area. And some of my clients don't want to donate organs and tissues, which is also okay. And some of them, from a medical point of view, are now not able to donate organs and tissues because of an existing or a past medical condition. So having all of that information included, sorry, and the healthcare directive is very important for your loved ones. And then life support was the other thing I wanted to talk about. So I'm so sorry about coughing. There was a woman many, many years ago in Florida whose name was Terry Schiavo, and she was hit by, I think, a drunk driver while driving her bicycle. I'm so sorry. And Terry was in a coma, and her husband wanted to withdraw life support and have her body cremated. And her parents, for their religious preferences, did not believe in life support. And because Terry didn't have a healthcare directive, the legal question was, what would she want in that situation? Would she want to be kept on life support, or would she want life support to be withdrawn? So you have three very well-intentioned people, her spouse and her parents, that love her unconditionally and only want what they think is best for her and what they each think that she would want. And this court case went all the way to the Supreme Court of the United States, which, if you're at that level in our judicial system, you've spent a lot of time, you've spent a lot of money, and sadly, oftentimes it's pretty, I don't know what the word is that I'm looking for, but it's just exhausting to go through a court case for that long, because it takes a long time to get to the Supreme Court level in our judicial system. But what happened is one of her old college roommates gave testimony, basically saying that when her and Terry were at a bar, that Terry had made a comment that she would never want to be in a permanent vegetative state. So based on that college roommate's testimony, the Supreme Court granted a judgment where they allowed her husband to withdraw the life support. Her parents wanted her to be buried, again in accordance with their religious preferences, but her husband wanted to cremate her. And from what I understand to this day, there's the husband has never communicated with her parents as to what he did with the cremains. So there's not a grave site for them to visit. And the saddest thing is, as I mentioned earlier, you have three very well-intentioned people that now have spent a lot of time and money, and now they don't even get along or speak to each other. So had Terry Schiavo had a healthcare directive, all of that could have been eliminated. So doing a healthcare directive, to me, is one of the most important documents, because I do think it's important. Even if you don't have a preference on life support, I think it's important to let your family and friends know that you don't have a preference. And that also applies for burial and organ donation. If you specify in this legal document that you don't have a preference as to those decisions, then the inference is the person that you name as your medical decision maker has your permission to make that decision for you. And some of my clients will say that they don't have a preference about organ donation, but they don't want to be a cadaver, or they're willing to be a cadaver. So you can even put in some parameters saying, I give my loved one the ability to make the decision, but I don't want this, or I am comfortable with this. And all of that is super helpful, because these decisions are made during an already very difficult emotional time for your loved ones. So that is how a healthcare directive works. And that is the fourth document in an estate plan. The other three documents, oh, it says, is the compost option legal in some states? So the compost in California becomes legal in 2027 under Governor Newsom. I would assume that other states that don't have composting currently in the works will eventually adopt it once our state probably, I think we're one of the founders of composting, and I think probably other states will take our lead, but give us the time to kind of work through the wrinkles of that process. And I think eventually composting will be a nationwide burial choice. But as far as I know, I think it's mainly the Western states right now that are offering that as an option. But I think eventually, like with most things, it will get adopted by all of the other states with time. So, um, okay, so yeah, so there's somebody who's posting saying that she lives in Wisconsin and she hears ads for green burials. Yeah, so there's the whole green burial phenomena is it's so new and it's so amazing. I know that when Luke Perry, who was on 90210, when he passed away, he had a suit made out of mushrooms because the mushroom would decompose his body naturally and quickly. So I don't know where his body was buried though in a mushroom suit. That would be something that would be worth Googling, but I know that there's going to be more and more options in the future as far as green burials, being a soil by a tree, being composted, because we're trying to get away from the gas emissions and the embalming, which is so like the embalming is a fluid that just is so toxic and it never goes away, that trying to avoid those types of things is just a great thing that is going to hopefully happen in the immediate future, at least in California in 2027. That's when composting becomes legal in our state. So when you have the medical directive, as I mentioned, that's one of 4 documents. The other 3 documents are your financial documents, and they are all interrelated. So when you create an estate plan, you have a trust, which is really the heart and soul of an estate plan. It does 85% of the work. And then you have a document called the durable power of attorney for financial affairs, which is really the second most important financial document. And then you have a special document that's used in tandem with the trust called a pour over will. And the goal of the will is to really not do very much work at all. So when you create a trust, metaphorically, you want to think of your trust like a bucket. So when you first start your estate plan, you're going to make decisions about the size, shape, and color of your bucket. And then once the trust is signed and notarized, that's when the trust exists. And that's when you get to the second part of an estate plan, which is just as important as doing the estate plan, which is a process that involves changing how your assets are titled. Because California has 2 laws that take us into probate when we die in the state of California. One is if you own real property that's not titled in your trust at the time of your death, then California makes that asset go through a court process called probate. The other thing that triggers probate in California is if you had liquid assets, financial assets titled in your name, like a bank account. If I had a checking account with $300,000 in it titled in my individual name that I didn't have a beneficiary attached to it, then when I die, one of the things my executor under my will, what they have to do is they have to find any other asset like that that's titled in my individual name that doesn't have a beneficiary attached to it. And when you add all those assets together, if their total aggregate value exceeds $184,500, then those assets only would trigger that court process called probate. So probate is a judicially supervised process where a judge is basically overseeing the administration of assets that are titled in an individual's name that do not have a beneficiary attached to it. So many people in California will create a trust because they own a house. And it doesn't matter how much equity you have in a house. You could just buy a house and have barely any equity in that house. But because you own a house in your individual name, if you were to pass away, that would take that asset through probate. And part of the problem with probate in our state is the fees are statutory, which means statutory means predetermined by law. And it's a percentage calculation based on the gross value of the assets before the probate court. So on average, right now, when you have just one house going through probate, those probate fees can be anywhere from $15,000 to $25,000 to $50,000. And that's because the fee is a percentage of the gross value of that asset. So it's really important when you own real property that that real property is titled in a trust and isn't titled in your individual name. And if you look dollars and cents at the cost of putting an estate plan in place versus the cost of what probate costs, it's unbelievably different. I mean, most estate plans can cost anywhere from $1,500 to $3,500. Whereas the average probate at a minimum, the floor is $15,000 for the cheapest probate fee, and it just goes up from there. So the cost of putting an estate plan in place and making all these decisions about who you want to be your medical advocate and who you want to be your financial advocate and who you want to inherit your assets, and having the ability through the estate plan to make all those decisions while you have capacity, and picking the people that you know and love that are better with money than others, is so much better, in my opinion, than not having an estate planning and having everything go through the probate court. Because one of the other problems with probate is that is a public process. So if my husband and I both died, and if we didn't have our real property in our trust and our financial assets with our trust and the retirement assets naming individuals as beneficiaries, then if we both died simultaneously, because probate is a public process, anybody could pull our wills and find out where our kids are living, how much money they're inheriting, their date of birth, social security numbers. All of that private and confidential information is part of that public process. But when you create an estate plan, one of the many benefits of it is that a trust is a legally confidential document. So nobody is entitled to read the trust through a public process. Whereas with a will, whether it's a pour over will, which is the special will that's used in tandem with a trust, or whether it's a testamentary will, which is the type of will that's used when there's not a trust, if you died and owned real property not titled in the trust, or had assets in your individual name that didn't have a beneficiary attached to them, that when you hit that magic number of $184,500 worth of assets, with the pour over will or with a testamentary will, or even without a will, those assets would go through that court process called probate, which means your beneficiary's information is part of that public process, and their date of birth, social security number, current address, and all that information in today's modern world of identity theft that you want to keep private and confidential. Through probate, all that information is public. So there's really three reasons why people don't tend to like probate in California. The first one, as I mentioned, is the cost. The second one is the fact that it's public. The third reason why a lot of people don't always love this court process called probate is because it's a slow process in our state. And that's because at a minimum, we have a law that says that a probate from start to finish has to be open for a minimum of 6 months. But the reality is because we have 3 sitting judges in our probate court who hear estate planning matters, trust administration matters, conservatorship matters, guardian matters, and contested matters, which is a lot of different areas of the law for 3 sitting judges in such a large county like San Diego. Our probate court, their judges' calendars are quite compacted. So if I filed a petition today to open a probate, it's usually about a month and a half to 2 months out before I get that first hearing date appointed, where we can get the executor in place as the administrator of the estate. So if it takes 2 months just to get that first hearing, and typically there's at least 3 to 4 hearings in an average probate, from start to finish, the average probate in California usually takes anywhere from a year to as long as a year and a half from start to finish. And that's a long time for assets to be held up in court. So that is what probate is. Those are the 2 things that trigger probate. So when you create a trust, part of what you're doing is you're deciding on who are the people that you know and trust that could manage those assets titled in a trust. And part of where that benefits you as an individual is that if you didn't have those assets titled in a trust, and if you lost capacity, as I mentioned earlier, then without these documents, the only way that your loved ones could deal with your state and federal income taxes, your car, your financial affairs in general, is by going through a different court process called a conservatorship. So having a trust is important because you're picking the people you know and trust to manage the assets that you title in the name of the trust should you lose your capacity. And then a durable power of attorney for financial affairs is similar to a trust, but it does something just a little different in that if you were to lose capacity, you're giving the person that you name as your durable power of attorney your legal permission to deal with all financial assets that are titled in your individual name. So an example of this would be if I was hit by a drunk driver on my way home from work, if my husband and I were refinancing our house, because our house is titled in our trust, There's language within the trust that gives my husband my legal permission to step into my shoes upon my potential future incapacity to sign my name on a legally binding document like a mortgage. If we didn't have these documents and if I was incapacitated, he'd have to go through that conservatorship process to be given the power to sign my name on that mortgage document. And then if I was hit by a drunk driver and if it wasn't my fault, it's the durable power of attorney that would enable my husband, who's named as my durable power of attorney first choice, to step into my shoes legally and hire a lawyer to file a lawsuit to preserve that statute of limitations to make sure that we could sue that drunk driver who caused this accident. And if my car was titled in my individual name, it's also my durable power of attorney that would allow my husband to get my car fixed and to deal with my insurance, my car insurance. And if it was April 15th and it was time to file our taxes, it's the durable power of attorney that would give him my permission to sign my name on our state and federal income taxes. So if you were to lose your capacity, between the powers that are enumerated in the trust and the powers that are in the durable power of attorney, you're basically covering all of your bases by making sure that all of your financial affairs are being managed by the people you trust that you've named as your trustee and durable power of attorney in those two documents. But what happens is when each of us pass away, the powers in a durable power of attorney die with us. And that's when the will comes into play. So basically the will steps in where the durable power of attorney leaves off. And the purpose of the will when you have a trust is you have a special kind of a will called a pour over will. And what the pour over will says is that when you pass, if there is an asset that's titled in your individual name that doesn't have a beneficiary attached to it, the will directs that the executor pour that asset over into the trust. So in a perfect world, the only asset that we really want the will to be dealing with are your vehicles, because most of us don't put our cars into our trust, because if you added them together, as long as their aggregate value is under the $184,500, those wills won't trigger that probate process. And because a trust is revocable, which means it's changeable, a trust works as a pass-through entity. So having assets titled in a trust doesn't have any greater creditor protection than assets titled in our individual name. So oftentimes when it comes to the trust, you're going to put the real property into the trust and you're going to put your taxable assets into the trust, but the cars don't necessarily have to go into the trust as long as their total aggregate value is under that magic number, which is the $184,500. So when you die, because a car doesn't have the ability of having a beneficiary attached to it, it's the pour over will that directs the executor who's named in the will to retitle that asset into the name of the trust after you pass. But what happens with the pour over will is if the real property is not titled in the trust at the time of your death, then because we have an asset that's not titled in the trust, the pour over will is going to grab the car plus the real property. And now we have to go through the court before we can legally pour those assets over into the trust. So you can have a trust and still have a probate, because it's how your assets are titled at the time of your death that determines whether or not we go through probate. And what happens oftentimes is when you create a trust, oftentimes you're going to hire your estate planning attorney to prepare a deed and put the house into the trust. But then in the future, if the mortgage rates go down, a lot of times people will take advantage of those decreased mortgage rates and they'll refinance their house. But unbeknownst to them, some of these mortgage companies will take the house out of the trust as part of the refi, and they don't tell you that they've done it. And that's how oftentimes a house that was in the trust comes out of the trust. And it's usually through a refinance situation. So for any of you who have an estate plan, if you've refinanced your house, which a lot of people have done recently, the way that you can check to make sure that your house is still titled in the trust is by looking at your property tax bill. And your property tax bill should show the name of your trust on it. And that's how you'll know that your house is still in your trust. Sorry. So the other document that we talked about is the trust and how it is revocable, which means it's changeable. And because it's revocable and changeable and works like a pass-through entity, the assets that are titled in the trust As I mentioned earlier, they don't have any greater creditor protection than they would if they were titled in your individual name. So it's really important that when you create a trust and when you put your real property into the trust, you still want to have a good umbrella policy on that house, and you still want to have a really good homeowner's insurance policy on that house, because you want to make sure that those assets are properly insured in case if there was a creditor claim, because having the house titled in the trust doesn't give that real property any greater protection than if the asset was titled in your individual name. And that's how those three financial documents work in tandem. While you're alive and you have capacity, you are the owner of these assets and the manager of these assets. So while you're alive and you have capacity, oftentimes the durable power of attorney and its powers aren't triggered because you're managing all of your financial affairs for yourself. And you're also the beneficiary of these assets while you're alive. So you can do with your assets whatever you want. So putting an asset in the name of the trust doesn't change the way that you use or enjoy or invest that asset. Only the title to the asset changes, but the way that you go about managing an asset, investing an asset, spending an asset doesn't change. And then if you were to lose capacity, that's when the durable power of attorney would spring into effect to give your loved one your ability to deal with the assets titled in your individual name. And then the trust has similar language that would give your successor trustee your permission to deal with those trust assets. And then when we die, the powers in the durable power of attorney die with us. And that's when the will steps in to deal with any asset titled in your individual name that doesn't have a beneficiary attached to it. And as long as there's not real property titled in your individual name, and as long as all assets have a living pay on death beneficiary attached to them, in a perfect world, the only thing that the will should really have to deal with are your cars. And as long as their total aggregate value is under the $184,500 magic number, then those assets don't trigger probate. And then the medical directive, as I mentioned, is its own separate document because those three financial documents are really interrelated. And then the one category of asset that we have that doesn't need the trust for tax reasons are your retirement assets. So for those of you who have an estate plan and have had one, and if you haven't reviewed or updated your estate plan in like 10 to 15 years, one of the biggest changes in the law is it used to be 10 to 15 years ago, estate planning attorneys would advise their clients to name their spouse as their primary beneficiary if they were married, and to name their trust as the secondary beneficiary on those retirement assets, 403B, 401k, IRA, SEP Simple, Roth. But now those laws have changed quite dramatically, that if you have your trust as a beneficiary on a retirement or even an annuity type of an account, that will trigger unnecessary additional taxes than if you would have named those individual beneficiaries by name. So for those of you who haven't maybe looked at your retirement beneficiaries in a while, that would be something I would encourage you to do, because if you look at your retirement beneficiary and if your trust is named as a beneficiary, I would encourage you to change that beneficiary to be people or organizations. Because if you have an individual named as a beneficiary, because they're an individual under federal law, they have options as to how they inherit that money. But when you name a trust as a beneficiary for retirement assets or annuity assets, because a trust is an entity under federal law, it has to take a lump sum. And generally speaking, when you lump sum a retirement or an annuity distribution, you're going to trigger some additional taxes that would be avoided if you took those monies over a period of years. And because a trust becomes irrevocable when we die, that puts the trust into the highest allowable federal income tax bracket, which is a second double whammy as far as an unnecessary tax that is triggered. So for those reasons, it's not advisable to have the trust any longer named as a beneficiary on your 403B, 401k, IRAs, Roth, Simple SEPs, or annuities. You want to always have people or charities named. And ideally, you want to have a primary beneficiary, a secondary beneficiary, and a third beneficiary to make sure that we don't run out of living beneficiaries. Because if all you have, for example, is your spouse listed as your beneficiary, and if the two of you died simultaneously, now we don't have a living beneficiary on that asset. So if we added that asset plus the value of the cars plus any other asset like it together, And if those assets added together exceed that magic number of $184,500, then we've just sent those assets through probate. So it's really important with your retirement and annuities. You always want to have a primary beneficiary, a secondary beneficiary. And oftentimes, if you ask the financial institution if you can add a third beneficiary, they'll let you. But oftentimes, the form only prompts two beneficiaries. So if you're super productive and wanting to make sure that you want to avoid probate, asking the financial institution if you can name a third beneficiary is a really smart and prudent thing to do. And again, my advice is to not have the trust as the beneficiary because that's going to trigger unnecessary taxes, but to name individuals or charities as the primary, secondary, and third beneficiary. So if any of you have refinanced since you've started your estate plan, I recommend checking your property tax to check title of your property to make sure that the house is still titled in the trust. And for any of you who have an estate plan that's 10 to 15 years old or older, I would recommend that you check your retirement beneficiaries to make sure that you don't have the trust named as a beneficiary for all the things that we just talked about. And then a newer change in the law that's recent is now we have some additional trustee powers that we're including in these documents. One is a digital asset power where you're giving your trustee your permission to access your emails, your computer, your password, your social media, your cell phone. So that's an important power to include in these documents because so much of what we do now is digital asset driven. And then we've got some tax laws that could potentially be happening and changing in the immediate future. Right now, the federal government gives each of us something called a federal estate tax exemption. And that's the amount of money that we can leave tax-free before we trigger a federal estate tax. And that amount changes every year. So when I first started practicing law, the federal estate tax exemption was around $475,000 per person. And that was like 23 years ago. Now in 2024, the federal estate tax exemption is $13.2 million for US residents and US citizens. But next year, the federal estate tax exemption is scheduled to go down to $5 million per person. So if you're married and if it goes to the 5 million, that means together you can leave 10 million next year. Or if you're single, you can leave 5 million. But in my experience, when it comes to these federal estate planning tax laws, oftentimes the federal estate tax exemption isn't lowered, nor is it flat taxed, nor has it gone away. But what usually happens is it stays where it's at and eventually it continues to go up. But this could be the first year in the years that I've been practicing law that maybe we'll see the federal estate tax go down, because right now in 2025, it's scheduled to go down to $5 million per person. So that's something for all of us to keep an eye on, because any amount of money that exceeds that federal estate tax exemption is subject to federal estate taxes. So one way of planning around that is if you're charitably minded, any amount of money in your estate plan that you give to a 503 C tax exempt organization doesn't count towards that federal estate tax limit. So for example, if I had a $15.2 million estate, and if I gave $2 million to the San Diego Humane Society and I gave the balance of my estate to my family, I don't have a taxable estate because the amount that would be subject to federal estate tax is now being gifted to a nonprofit organization. So there are ways of planning around the federal estate tax, but it's important to know what your net worth is, not gross, but net, and to be mindful of what that federal estate tax exemption is so that you know whether or not you need to plan around it. Granted, there could be worse things than paying taxes because taxes do serve a purpose, but I don't make that decision for people. Some people come in that are very tax adverse. Other people are very tax friendly. My job is just to explain what the laws are and what your options are. And like, you make the decision as to how you want to deal with your particular situation. But the federal estate tax exemption is something to keep an eye on. There's also something called a capital gain forgiveness that occurs when we die. And what a capital gain forgiveness is it's the forgiveness of the equity in an asset from the day that you bought it to the date of sale. So an example of this would be if I bought a property for $600,000, but if at the time of my death, the property appreciated to $2.6 million, so there's a $2 million gain. If I give that asset to my spouse and or kids at the time of my death, assets that are received after a person dies get a full stepped up basis, which means the capital gain is forgiven. So if my husband wanted to sell our house and move into a smaller house closer to the kids or into a one-story house, it's best, with all due respect, to wait until a spouse dies, because you get that full forgiveness of capital gain 100%, as long as the asset is co-owned by you and your spouse equally. And then when the surviving spouse dies, those assets get a second forgiveness of capital gain, and those assets can then be distributed to your beneficiaries. And if any of them sold the asset close in time to the day up to the date of your death, then they pay no capital gain either. So capital gain is an important forgiveness of appreciation in an asset, as long as the asset is inherited and not gifted. So I had a lady call me one time and she said, look, I know I probably should do an estate plan, but I'm a very simple person and I really don't like legal documents. So what I'm going to do, because I have one adult child, is I'm just going to add her to the title of my property. We'll be joint tenants with rights of survivorship, so that when I die, the property won't go through probate, because joint tenancy avoids probate as long as you have a surviving joint tenant living. And then I'm just going to add my daughter onto title of all of my financial accounts, because she's my one and only child and she is my pay on death beneficiary. So by doing that, I guess I don't need an estate plan. And she says, what's good or bad with that? And I said, well, the problem with adding your daughter onto title of your property is if you were to let her inherit the property after you die, she would get a full forgiveness of capital gain 100% as to the full value of that property. But when you add her onto title to your property while you're alive, because it's a lifetime gift, there's no forgiveness of capital gain. And then I said, is your daughter married? And she said, yes. And I said, does she live in California? And she said, yes. And I said, do you like her spouse? And the gal said, not really. And I said, well, that's the other thing to think about, is if you add your adult child as a co-owner of your assets, those assets are now subject to that loved one's liability. So if your daughter and her husband got a divorce, then her husband could try to claim that part of your house is his through the divorce, because you've added your daughter on title as a co-owner. But if the house was in a trust, then you would own your house. And if your daughter and her husband got a divorce, it doesn't impact your house because she's not on title to it. And then if you had the house still in your estate at the time of your death, all that capital gain is forgiven, and your daughter would inherit the house as her sole and separate property. So if she's still married at the time of your death, when you have an inheritance, as long as you put it in your own separate and individual name, it's an exception to community property law. So when your daughter inherits, if the house goes into her name and her name only, it's her sole and separate property, which would benefit your daughter, because legally, if your daughter's spouse were any kind of an accident, bankruptcy, or had any kind of creditor issues, all of their community property is reachable by both of their creditors. But if it's her spouse's creditors, then her separate property is protected and is not reachable by his creditors. And then if sadly there were a divorce, inherited assets that are kept as your sole and separate property are protected from that divorce. So there's definitely pros and cons to all of this. Not every situation is the same. But when I explained to this woman about how all this worked, I also let her know that just a few weeks before she called me, another client had called me in tears, because when she took her trust to the bank and was asking the bank to title her bank account into the name of her trust, the banker said it was easier and less forms if the client just added her adult child to title of the bank account versus putting it into the name of the trust. Well, what happened is she added her child onto the title of the account, not knowing that that child had back taxes that she had owed the IRS. And when the IRS was doing an audit of her daughter's social security number, her daughter's social security number is now tied to her account, and the IRS came without any notice, because that's how they do it. And they took $91,000 out of this woman's checking account, which basically took her whole account away. So she called me asking me if I could fix that for her. And I had the unfortunate job of explaining to her that once she made her daughter a co-owner of her asset, her daughter's creditors could come and take those assets, which the IRS did. So for all of those reasons, it's really important to understand that one of the many benefits of an estate plan is if you lost your capacity by having these documents, you are nominating people to manage your assets should you lose capacity or after your death during a trust administration. And legally, that's very important because they don't co-own your assets. Whereas when you co-own assets with people, their liability and their creditors become your problem because your asset is counted as theirs. So you don't have protection. And sadly, I don't quite understand why this happens as often as it does, but one of the things we ask clients to do once they put their trust in place is to retitle their assets into the name of the trust, or to name the trust as the pay on death beneficiary on their taxable assets, so that those assets don't trigger probate when they die. And it is really surprising to me how many banks and financial institutions give the wrong advice, bad advice of saying, hey, it's easier in less forms to just have your adult child be a co-owner of the asset than to have the asset go into the name of the trust, or have the trust as the pay on death beneficiary. And I just want you to know, for those of you who have an existing estate plan, if you ended up with the unfortunate luck of talking to somebody who gave you the easier advice, my recommendation is to go and undo that. You don't want your loved one, whether it's a child, a niece, a nephew, a best friend, co-owning assets with you, because now your assets are liable to their creditors. You want your assets titled in the name of the trust, because the trust already has language that would give your loved ones your permission to manage those assets if you lost your capacity. Or for assets that are titled in your individual name, that names the trust as the pay on death beneficiary if it's taxable, or if it's a retirement asset, names people or charities. The purpose of the durable power of attorney is to give those loved ones your permission to deal with those assets, manage those assets, should you lose your capacity. So for all those reasons, there really is no good reason, aside from the banker's selfish point of view of not wanting to do as much work, to ever have somebody come on as a co-owner of your asset, because legally you want those assets in the name of the trust or in your name, knowing that they could be managed by your durable power of attorney if you lost capacity. So those are some common mistakes I've seen people make as far as adding people to title of their assets, which isn't necessarily always a good idea. The refinancing of real property is another thing that I've seen happen quite often, especially recently, where people will have their house in the trust. They'll refinance the house to take advantage of the lower interest rates. And then unbeknownst to them, the house is no longer titled in the trust. And people understandably, but mistakenly think, oh, I have a trust, I have everything in order. But the way this all works is when each of us pass away, it's how our assets are titled at the time of our death that determines whether or not our estate is subject to probate. So whether it's real property, a checking account, savings account, investment account, taxable assets need to be titled in the name of the trust, or name the trust as the pay on death beneficiary. And it's the tax deferred assets like annuities and retirement assets, because those laws did change about 10 years ago, that you want to have individuals named as beneficiaries and not name the trust. And for any of you who still happen to own a timeshare, which I know timeshares aren't quite as trendy as they used to be because of Airbnb and Vrbo, but if you still have a timeshare that you own, you want your ownership in the timeshare titled to you as trustee of your trust, just as your real property would be titled. So the way that you deal with a timeshare is you want to contact the company who you bought the timeshare from, because they tend to do all their deeds internally. And you're going to mention to them that you want your ownership of the timeshare retitled to you as trustee of your trust. And that's how you would have the peace of mind that that asset wouldn't trigger probate, and that asset would be managed by your trustee if you lost capacity or at the time of your death. Because you don't want timeshares outside of a trust, regardless of where they're located. And then the other thing to understand about a California trust is when you put a California trust in place, It is valid throughout the United States. So if you did move to another state, this California estate plan is legally binding in any of the United States. It's just going to be interpreted under the laws of the state that it's written. So if you move to Arizona, hypothetically, having a California estate plan in Arizona isn't really the worst thing, because a lot of our neighboring states are community property states like we are. But the farther away you get from the West Coast, the more problematic that is, because there's only, I think, 11 or 8 community property states in the United States, and all the other states are separate property states, which means that their laws are very, very different than ours. So when you have an estate plan, ideally you do want to review and update the documents about every 8 to 10 years, because the language needs a refresh, because the tax laws are constantly changing. And if you moved out of state, that estate plan is valid in all of our United States. And you can put assets into a California estate plan that are located elsewhere. So as long as it's within the United States. So if I bought a vacation home in Hawaii, I can title that vacation home into my California trust because it's located in the United States. But what you can't do is you can't put assets outside of the US into a California estate plan, because the US has no jurisdiction outside of its borders. So if you had another property in Canada, you'd have to do a similar estate plan to deal with that property, but under the Canadian laws, because the United States has no jurisdiction over there. So some of my clients that are dual citizenship, or that have inherited assets outside the US, they'll have 2 estate plans, one for assets located in the US and one for assets located in another country. And the tax laws can change, which is not my area. So if you do inherit assets internationally, you definitely want to talk to a CPA before you start moving assets into the US, because there are tax issues to consider. But as far as our taxes go, when each of us pass away, the federal government does give us that federal estate tax exemption, which is that amount of money that each of us can leave tax-free. And that amount changes every year. And right now in 2024, it's $13.2 million per person. And that's pretty much everything about estate planning that I wanted to go through. I'm so sorry about my throat drying up a whole bunch. But if any of you have any questions that you want to post before we conclude, or my email is on that handout if you have anything personal in nature that you want to ask. And for those of you who have your ARAG legal insurance, if you haven't used it, I would definitely encourage you to use it. It's such a great legal insurance, and estate planning is a covered benefit. We accept ARAG, so if you have ARAG, we can help you put in an estate plan, review or update an estate plan. And I'm assuming it's probably open enrollment or close to it now, that you can certainly ask the questions and find out how all that works. And that's pretty much estate planning 101. So thank you guys so much for your time. I don't see any other questions coming through. So I'll just go ahead and end this presentation and say thank you again for checking in today and learning about estate planning. Take care.